Is a separation agreement required to get a no-fault divorce in Virginia? No, it's not required. It's often advisable, but it's not a requirement for a no-fault divorce. If the parties want to get a divorce after only 6 months of living separate and apart, and they have no minor children, they are able to do that with a written agreement between them. Now, one of the benefits of having a separation agreement or property settlement agreement or marital agreement is that the parties know what to expect. A spouse who files what they believe to be a no-fault uncontested divorce in Virginia may be surprised when his or her spouse answers that case and files a counterclaim based on fault, or answers that case and asks for spousal support and equitable distribution. So a property settlement agreement or a separation agreement provides certainty and minimizes the risk that you will have a surprise during your divorce case. The other benefit of a property settlement agreement is that you can avoid equitable distribution in your divorce. If a husband and wife are not able to agree on how to divide up their property and allocate their debts, upon the request of either one of them, a judge can just decide how to divide up marital property and how to allocate marital debts between the parties. So agreeing beforehand in a written agreement relieves the parties from the expense and controversy that goes along with a contested divorce case involving equitable distribution. Now, what happens if the parties file divorce and they don't request equitable distribution, or a party is served with a divorce complaint, there's personal jurisdiction over that person, and they don't request spousal support? The result of not requesting that relief or reserving that relief in a Virginia divorce case is that you lose those rights. If the court had personal jurisdiction over you, it had the right to deal with your property interests and the right to receive support and the right to have one's marital property and marital debts divided through equitable distribution can be lost. And what the parties are left with in that circumstance is they fall back onto the legal rights that they would have as if they were not married. So if one spouse alone has title to real property, that spouse, after the divorce is finalized, is the owner of that real property. If only one spouse is liable on a debt, even if the debt was used for marital or household purposes and could have been divided up by the judge if the party had requested it, upon divorce, if that party didn't request equitable distribution, and again the court had personal jurisdiction over that spouse, they're now stuck with that entire debt. So for the sake of certainty and to avoid surprises and unnecessary costs, it's often best for a married couple to negotiate a separation agreement or a property settlement agreement and settle the incidents of their marriage rather than being left with the legal rights, if they don't avail themselves of the rights in a divorce case, or face a contested divorce case where a judge will end up making those decisions for them. You should consult with your attorney regarding whether a separation agreement or property settlement agreement is advantageous in your circumstances.